Good morning again. Please be seated. Go ahead, call the case if you would.
Good morning, Your Honors. The matter before the court this morning is the case entitled Politella versus Windham Southeast School District, case number 23 AP 237. Representing the appellants Dario and Shujen Politella is attorney Ronald Ferrara. Present with attorney Ferrara is attorney Matt Goins. Representing the appellee state of Vermont is attorney David McLean. Representing appellee Windham Southeast School District is attorney Kristen Wright.
Okay, thanks very much. Counsel, come on up, please.
Good morning.
Yeah, good morning. If you would identify yourself and your client for the record before you start.
Yes, Your Honor. I'm Ronald Ferrara. I practice down in Brattleboro, and seated behind me here is Dario and Shujen Politella and their young son, LP.
Well, good morning. Thanks very much.
Appellants in this case, and Matt Goins is my associate. Not yet licensed in Vermont, but getting there. So,
Is it Matt Dillon?
Matt Goins.
Oh, Matt Goins. Okay. That's
And,
Matt Dillon.
He helped me with the briefs. So, and may the court be pleased. From watching the previous proceedings, I understand you only get to make about 1 point before the question starts. So
That depends.
If you're
Depends. Sometimes you don't even get that.
The 1 point would be this, and that is we're here on a very narrow issue, the Federal PrEP Act and the preemption that exists thereunder. As I had briefed in the appellate side of things, the only claim that's preempted is willful misconduct resulting in death or serious bodily harm, which is not the case
So
here.
you've got no issue with the act otherwise, right? You're not challenging the constitutionality of the act in any way.
No.
Right.
The act is Congress's idea of what needs to happen in certain circumstances, but it only has one cause of action, which is this willful misconduct thing that is preempted. They go to the DC Circuit, or you take an alternative remedy under the countermeasures, injury protection. Well, there's a mechanism by which administratively, as a last resort, if you are shut out of the court process, you can go try to get some money there. But none of that applies in this case. These are all state level claims. And I believe the court below Judge Kanan ruled wisely when he said that, it's a well-pleaded complaint, but he thought it was preempted and based that primarily on the case of Parker v. St. Lawrence, which is a case from 2012 that's not a COVID case. And so this is an area of law now that's been changing quite a bit. There's a lot of cases bubbling up through the courts. And as you might have seen in the brief, there's a fairly large citation to all the circuits that have decided that state law claims belong in state court. And so they're remanding them back down. And our Second Circuit in Solomon v. St. Joseph's Hospital came to that very same conclusion. The United States Supreme Court, when it didn't want to hear Saldana out of the Ninth Circuit, basically is letting that rubric stand. Let the circuits decide that they don't want to hear these state law claims. Let the state courts, yes, Your Honor?
I'm sorry, I didn't mean to interrupt you. In Parker, how can you distinguish that case from the case at issue here? In other words, facts or law? You said it was an older case and it didn't involve COVID, but that's, I don't think, enough. How do you distinguish that case?
Well, Parker was during the H1N1 swine flu pandemic that occurred back in 2012. As I indicated in the brief, in the Parker matter, the school nurse was certainly a qualified person with respect to the protections of the PrEP Act. And in this case, we have John and Jane Doe's listed. We have no information about them yet. There's factual questions to be answered about who are the covered persons under this PrEP Act.
In your brief, you acknowledged that all of the people involved here were agents of the state. And doesn't that meet the definition of a covered person pursuant to the language of the statute?
It might if they had filed an answer and actually alleged it as a defense. The immunity that the state and the school would seek in this matter is essentially question facts. You have to satisfy certain requirements from the jurisdiction having authority and from the CDC and from the Health and Human Services Secretary's declarations and from our own Department of Health. There's a lot of things you got to do before you get qualified for immunity. That's an issue that needs to be decided at the trial court. We're here today.
Didn't the trial court do that? Didn't the trial court do that?
We had no hearings. We had none of that. I don't even have an answer to the amendment.
Well, there were motion practice.
Yeah, but as far as raising an affirmative defense of sovereign immunity or immunity under the PrEP Act, that never happened. So,
Well, I'm just a little confused now. Didn't the school-related defendants all raise the PrEP Act and say that the state lawsuits couldn't go forward?
they did raise it, and Judge Keenan listened to that argument, but the judge, with all due respect, was wrong. And rightfully so, because I indicated the law's changing in this area. The idea that the PrEP Act provides blanket immunity is eroding. There are cases bubbling up through the state courts. There's one in California that just recently came down where they've decided not to allow defendants to raise it in a remdesivir case, which is another countermeasure under the PrEP Act. You've got a case out of Ohio where all the conduct prior to the injection of the countermeasure is fair game. But after that, apparently, it covers a multitude of sins. But anything that happens before you actually get to the application of a countermeasure, and it has to be by a covered person.
Doesn't that include the planning? I think there's even something in the language about lining people up
There
to
is.
get it. So I'm really curious as to why the people that are defendants here weren't covered.
Because, well, for example, the vice principal of the school that spoke to Mr. Politella 2 days before the week was even a countermeasure present on the premises, indicated that his son would be perfectly safe if he brought him to school that day. There were some questions about this, but he was told 2 days before any countermeasure ever was there, and the PrEP Act might have attached, it'll be okay. This won't happen. And then, lo and behold, the exact thing that they were told to happen or they were warned about happened. So that kind of stuff, those kind of conducts, pre-injection liability should be allowed. Shouldn't disallow it just because the PrEP Act seems to be such a sweeping immunity statute. Because if you do that, you create, well, some bad public policy, because this kind of mistake can be repeated without ever having any judicial review. You could have this kind of stuff going on all over the place. And since this is an issue of first
Well, if it's
impression,
intentional, it can go to the federal court.
right, but it's not. In this case, everybody can agree this was a mistake. It was a mistake based on what we argue was reckless conduct and probably some very gross negligence, but it still doesn't rise to the level of wrongful misconduct resulting in death or serious injury that the federal statute needs to go over to talk to them in DC. So, with respect to, back to Judge Kanan's order in May, he had indicated that he was ruling strictly on, preemption grounds. He says, these claims remain preempted, quote, by the PrEP Act, and inasmuch as the exclusive remedy under the statute is a federal cause of action to be brought in federal court, the complaint must be dismissed for lack of subject matter jurisdiction. And he's citing to Parker. You asked about why Parker needs to be distinguished. Well, it's because Parker, back when they wrote this, was one of 3 cases that was kicking around with the PrEP Act. Now you've got hundreds. And these kind of state law claims that we have here, well-pleaded complaint, as Judge Kanan will tell you, are not preempted. Parker was wrong. Parker would have all claims preempted and sent over to the CICP.
Well, isn't there general preemption here? Because the federal government has said that if a covered person administers a measure related to the PrEP Act, they cannot be sued in court, state court. Isn't that in itself, it provides them immunity, but it's also preempting the state from taking on those claims. Is that right?
Well, the way that the PrEP Act has been glossed, if you will, in various places tends to indicate that you have to be the actual one administering the countermeasure. And in the case of program planners, which is what you were speaking about, the broadened immunity, well, those kind of protections didn't come necessarily from Congress. They come from the unelected Secretary of Health and Human Services declaration, and then the General Counsel of the Health and Human Services department in Washington who have decided that this is their opinion, that these kind of things are covered. But it doesn't carry the force of law. It's not like Congress wrote that in the statute.
But I was asking you about preemption.
Well,
not covered.
preemption with respect to these claims, again, under the language of the PrEP Act says there's only one claim that's preempted. With respect to the state being preempted from certain kinds of regulatory activity, I can say this, the PrEP Act puts in a ceiling above which state cannot regulate any further. These countermeasures come to town, they can't be labeled any differently, the state can't require them to be administered any differently, you can't measure them any differently, keep them at a certain temperature, don't decide you want to market them any other way. It's a very, very canned thing from the CDC. That's what the preemption language is in this statute. It's designed to make sure that the Department of Health, when they get these vaccines or countermeasures, doesn't do anything other than what the CDC wants them to do. In this case, that includes getting consent. In this case, it includes the requirement that you have the opportunity to reject. But in this case, the parents were deprived of that by mistake. I think, unless you have any further questions, I see my light blinking. I'd like to reserve back the balance of my time to rebut the state.
Okay, all right, thank you. We'll hear from.
Thank you, Your Honor.
Thank you. Hear from Counsel Diabelli. Are you folks dividing time?
I doubt I'll use the full 15 minutes, and I'll see whatever time I don't use to Attorney Wright.
Okay. Great. Just come on up and for the record, please introduce yourself and identify.
Good morning, David McClain for the state defendants.
Thank you.
The lower court should be affirmed because it correctly interpreted a federal statute that was passed to protect people who are trying to save lives during a pandemic. The PrEP Act provides immunity to all state law and federal claims for individuals who are involved in the administration of life-saving techniques that are covered by the Act.
So, Mr. McLean, is it a immunity statute or is it a preemption analysis?
Good question. It's a combination of the two. There's a specific immunity provision, 42 USC section 247D-6D-A1 says that a covered person shall be immune from suit and liability under federal and state law with respect to all claims for loss caused by, arising out of, relating to, or resulting from the administration of a covered countermeasure. So there's that immunity provision. Then later in the statute, which is 42 USC section 247D-6D-B8, there is a provision that preempts any state law that might tend to override that grant of immunity. So it specifically precludes the application of state statutes. For example, in one of the supplemental authorities that I filed just the other day, Happel v. Guilford County Board of Education in North Carolina, the state had passed a statute saying that parental consent was required for the administration of vaccines during a pandemic. And the court determined that that state statute was preempted and the defendants were entitled to immunity because of that preemption.
So would it be your position then that if this claim was about the failure to administer the vaccine, it would be a different case?
Correct. So, well, potentially, if let me start by saying that the cases the plaintiff relies on follow a fairly familiar pattern where defendants get sued in state court, the defendants removed to federal court and argue that the PrEP Act completely preempts state law such that the case should be heard in federal court. The federal court says, well, not actually, because there are claims that can fall outside the PrEP Act, misfeasance in the handling of a pandemic, failure to require spacing, social distancing, masks, those sorts of things are not something that would be precluded by the Act.
Why isn't misfeasance the same as giving by mistake an injection to a young kid that wasn't going to get it? Why isn't that misfeasance? Isn't that the same?
Because it's the administration of a covered countermeasure by a covered individual, the plain language of the statute.
So it is misfeasance, but it's a particular kind of misfeasance that gets swept up in the language of the act.
Precisely. Yes, it's a particular, very focused immunity that the statute provides.
The
So that,
countermeasure being the vaccine itself, the countermeasure being the application of the vaccine.
exactly. Yes, the vaccine, and the vaccine is enumerated in the Secretary's Declaration of Pandemic.
Do the feds have the power to preempt our common law?
Yes, Your Honor, it's all state law claims,
Including the common law?
including torts, yes. So
Where does it say that?
it says that a covered person shall be immune from suit.
Well, you're referring to the statute, but I'm asking you, where does it say that the federal government has the authority to preempt common law claims in states that were derived from, well, based on our Constitution? Common law coming out of grand old England.
Yes, yes, I understand where you're coming from, Your Honor. And frankly, this is not a question that I had thought of before today. However, I would say that under the supremacy clause, the federal government has the authority to provide this kind of immunity to individuals who are acting in accordance with the terms of the statute. And the plain language has been construed by many other courts in other states under virtually identical factual scenarios to preclude such tort claims, common law claims. That is the plain meaning of the statute and intent of Congress.
So, Mr. McLean, then I think I'm just trying to understand your response to our Chief Justice's question. You're drawing that distinction that the plaintiff's claims are based on the administration of the vaccine, not on allegations such as negligent failure to provide one. Is that right? Kind of on the common law tort negligence when you talk about misfeasance.
So yes, I think I understand where you're coming from. When I use the term misfeasance, there are other kinds of measures that can be used to combat a pandemic, the social distancing, masking, other types of efforts to slow the spread of the pandemic. Those are not covered countermeasures under the terms of the statute, whereas the administration of the vaccine is clearly a covered countermeasure. So even if they missed a student, they thought a student should not get one, I think that they thought, yeah, I see.
Thank you.
Yes, I'm so glad I could help.
You did.
In any event, the weight of authority clearly comes down in favor of the defendants having immunity in this case. And the lack of consent is causally related to the administration of a countermeasure by covered individuals, therefore immunity applies.
So is it agreed between the parties here? That is, does the appellant agree that I know it's alleged that it's not claimed, but is there agreement as to the facts, that the facts do not amount to willful misconduct?
There are no allegations of willful misconduct.
No allegations.
Correct. And this did proceed through motion to dismiss. We can take the allegations in the complaint as true, and the trial court correctly dismissed this matter. Thank you.
Thank you very much. How much time does the appellant have, please?
Appellant has 4 minutes and 34 seconds remaining.
Counsel?
We're going to split the time.
Huh? Oh, I'm sorry. Yeah, wait a second. That's right. I forgot, Am I a potted plant? I know that's what you're asking. No, you're not.
Kristen Wright, I am representing the school defendants.
Thank
I
you.
don't have any argument to add beyond what my colleague stated. Happy to take questions as to the applicability of this to any of the school defendants.
I guess not.
Thank you.
Thanks very much. Okay, so now, how much time again, please?
Appellant has 4 minutes and 34 seconds remaining.
Counsel?
Hello again, Your Honors. Thank you. Real briefly, a couple of things with respect to the words you were focusing on, failures, misfeasance. That's really the cause of the harm in this case. The vaccine has absolutely nothing to do with it. All of the harm alleged in this complaint stems from breaches of duty, failures, and procedural breakdowns at the operational level.
Is there a claim of willful misconduct in your complaint?
There is not, and in Judge Canaan's first order dismissing the original complaint, he had indicated that that was the case, and there is no claim of willful misconduct here.
Isn't that
But-
why he gave you the opportunity to amend? Didn't he give you the opportunity to amend?
I did, and we're living with our amended complaint right here, Your Honor. And in this case, I'll tell you the difference between the two complaints in a nutshell. One is, this one has a constitutional claim that I can't imagine is really preempted, and that's something we should really think about. And the other is that in the first complaint, we had alleged that there was proper training of these John and Jane Does. And in the second amended complaint, we're alleging there was no training. The failure was so abject that there was no way to get this right if they were trained. And the training requirements are key because that's what leads to the immunity under the PrEP Act. So on the face of the complaint, they don't get any immunity unless they can prove that they've satisfied all these requirements. With respect to what learned counsel for the state had indicated, the case out of North Carolina, Haple, he had just mentioned that he had supplemented the authorities. This court should take a look at what's going on there because just the other day, and I mean on the 21st of May, the Supreme Court of North Carolina had granted cert to one issue, which is the same issue before you here, whether the state constitution and statutes are preempted by the PrEP Act. And I'll give you the site. It's Haple versus Guilford County Board of Education. And it is North Carolina Court of Appeals case number 23-487.
Did you submit it as supplemental authority?
I did not. I only just got this the other day. I realized that it was.
Would you file in that?
I realized that the Supreme Court is taking it up down there, so it's something to look at perhaps before you make your decision. I have nothing else to say unless the court has questions,
I guess so.
other than you really should reverse and remand this with instructions. Thank you very much.
Thank you. Thank you both. Please call a conclusion.
The next hearing for the court is scheduled for 1